immigration compliance is critical. You need to have documentation to prove that, to prove the employer-employee relationship per se. All you need to do is to show that you control the employee's work and you are managing their work at the client site. In terms of how to avoid scrutiny, as long as you are compliant and have all the paperwork that shows the agreement that you have with the end client, what work the H-1B employee will do at the end client, what are the requirements for the end client, and the distinctions that I made between whether it is a discrete project for an end client versus whether it is a headcount increase for the end client. As long as you have clarity on that, if it is the latter, you should get the job description and the requirements for the role and ensure that the employees that you place at before you place the employees at their role, so that you can confirm that those employees will qualify for H-1B. Um, as long as you have all your documents, I don't anticipate that you need to do anything extra on top of it, but you do need to maintain your corporate documentation and your contracts fairly carefully and more diligently and much more organized, so that if you're ever questioned about it, you have them handy. And it may be worth discussing this change with your end clients to say, so that they are prepared for providing that information. There are plenty of clients that we've heard where the end clients are hesitant and reluctant, and sometimes outright deny any requests for cooperation for H-1B for employees placed on their site, on client side. And it's worth proactively bringing this up with your end clients so that you can avoid any compliance issues or any scrutiny down the road. But if you are compliant and if your end clients are cooperative, then it should not be an issue whatsoever.